Welcome to the Explainer. Today, we're tackling a massive headache for developers, creators, and SaaS founders: how to actually shield your proprietary work from hungry machine learning models. If you're producing valuable code or data right now, you know AI scraping is absolutely relentless. So we're diving into the source material detailing a very specific defensive tool called the Anti-AI Training Restriction Addendum. We're going to break down exactly what it is, how it functions, and exactly how you can implement it yourself. So, can you actually stop AI from scraping your work? It's literally the question on every creator's mind right now. You might think just slapping a no AI tag on your website or tweaking your robots.txt file is going to be enough to stop technical scraping, but let me tell you, those are paper tigers. They don't have real legal teeth. Scrapers can, and they frequently do, completely bypass those technical crawl directives. To actually protect your work, you need a mechanism firmly grounded in contract law and copyright restrictions. Okay, let's look at our roadmap for building this legal shield from the ground up. We'll be hitting Section 1, the foundation, Section 2, the mechanism, Section 3, the blueprint, Section 4, deployment, and finally, Section 5, the caveats. Right, let's jump straight into Section 1, the foundation, defining the legal shield. We have to start with the absolute bedrock, the Anti-AI Training Restriction Addendum. Now, the crucial thing to understand here is that this is not some universally recognized standalone license. You aren't going to find this sitting next to a standard MIT or GPL license. Instead, think of it as a bolt-on contractual limitation. It's a custom clause or a supplemental term that you attach to your existing terms of service, your software licenses, or your API agreements. Its explicit purpose is to restrict your content, whether that's your code, text, images, or datasets, from being swallowed up for machine learning training, model fine-tuning, or dataset ingestion, without your explicit upfront permission. Moving right along to Section 2, the mechanism, how it actually protects content. Now that we know what this addendum is, how does this thing actually work as a barrier? Well, it relies heavily on contract law and legal deterrence, rather than just hoping technical roadblocks hold up. It establishes a firm legal restriction that explicitly prohibits actions like embedding your content into vector databases for AI retrieval. It exercises licensing control by adding a very strict use limitation. But honestly, its biggest power is deterrence. Companies are basically forced to comply because violating your terms introduces the very real legal risk of a breach of contract, potential damages, or injunctions. And of course, you can back all this up with enforcement support, like API access controls or metadata tagging to catch violators red-handed. I really love this quote: "You can view or use, but not use for AI training." It just brilliantly hits the nail on the head regarding this core licensing control concept. You're explicitly separating traditional, everyday copyright use from the modern threat of machine learning ingestion. You're telling users, and more importantly companies, hey, yes, you can view my website, you can use my software exactly for its intended purpose, but the line is drawn at AI. There's zero implied license for machine learning use. For you as a creator, establishing this boundary is absolutely vital in today's digital landscape. Which brings us to Section 3, the blueprint, crafting the perfect clause. Okay, so what does this actually look like on paper? There is a massive difference between having strong, specific contract language and writing vague, frankly, unenforceable garbage. If you try to use overly broad phrases like any AI use whatsoever, or if you demand impossible technical restrictions like this cannot be viewed by AI systems at all, you are actually weakening your shield. An unenforceable global jurisdiction claim with no real legal grounding is just going to get thrown out of court. Instead, you need incredibly precise definitions of what constitutes AI training and machine learning models, and you must clearly map out the exact scope of the restricted content. If you want to build a truly strong defense, you absolutely have to include these essential elements. First, clarify exactly what data is restricted. Are we talking about your source code, your API responses, your documentation? Nail it down. Next, explicitly state that you, the provider, retain all ownership. It is also super smart to include explicit exceptions, things like allowing internal non-commercial analytics or specific security research, so your license doesn't accidentally break normal everyday business operations. And crucially, you need strict enforcement and termination clauses detailing your legal remedies. Because this stuff gets incredibly complex really fast, ideally, you want this drafted by intellectual property lawyers or software licensing specialists, rather than just copying and pasting a generic template you found online. Let's pivot to Section 4, deployment. Where to display it. Think of this as your battle map, because honestly, a shield is totally useless if you just leave it sitting in the armory. If you want these terms to hold up in court, user acceptance is critical. For your websites and APIs, this needs to be front and center in footers, dataset download pages, and documentation headers. For software and apps, you want to use click-wrap agreements where the user actually has to physically check a box on the installer screen to accept it. For your code repositories, put a badge in the README and drop the language right at the top of your license file in the root directory. Putting these terms directly in front of the user's face is absolutely essential for primary legal validation. Now, while you're deploying this, you've probably seen these informal markers floating around the internet. Things like a little robot with a prohibition sign, the stylized no AI symbol, or text tags like NATL, which stands for No AI Training License. And look, while these are super helpful for quickly signaling your intent to human visitors, you have to remember one thing. Automated scrapers literally couldn't care less about your cool stickers. These visual symbols carry absolutely zero legal weight on their own. They have to be backed up by the comprehensive contractual addendum we just finished outlining. All right, time for a reality check in Section 5, the caveats, limitations, and legal conflicts. Before we wrap up, we need to acknowledge the blind spots here. Because AI scrapers can and absolutely will bypass technical enforcement limits, your legal deterrent strategy can get incredibly messy. For example, if you're running a fully open source project, adding these AI restrictions can directly conflict with the core ethos and the exact legal wording of established MIT or GPL licenses. That's a massive headache for the developer community right now. You also have to navigate tricky jurisdictional differences. What's perfectly enforceable in the US might not hold any water in the EU or Asia, especially where massive data privacy laws like GDPR intersect with training restrictions. Furthermore, you have to carefully define fair use and research exemptions, otherwise your entire addendum could just be completely invalidated in court. And here is a massive caveat that trips up so many people. Attempting to control the downstream outputs of a machine learning model is usually an unenforceable nightmare. Think about it. Once your data is swallowed up inside that black box, proving that a specific output was generated using your specific proprietary data is almost impossible. Therefore, your addendum has to strictly focus on restricting the initial dataset ingestion and the input. Basically, you are guarding the front door, not chasing the ghosts out the back. So, we've walked through how to define, build, and deploy a contractual shield to protect your valuable content from being ingested for machine learning. But as we close out this explainer, I want to leave you with this final thought to ponder. We are in an arms race where scrapers are growing increasingly advanced and technically evasive. When those technical walls inevitably fall, is the pure threat of a lawsuit actually going to be enough to stop a global AI giant from ingesting your life's work? It's a heavy question every creator is going to have to face. Thanks for joining me for this explainer.